Great article by Lord Dragon, which was released on February 17th of just last month. Suppression hearings over the security interruptions by the federal government in the pretrial hearings of the Guantanamo 4 charged for the 9/11 attacks. John Ryan wrote the article, and I'm going to be putting it in the description. So let's get right to it. Coordination between the CIA and the FBI investigated those responsible for the 9/11 attacks returned to center stage in Guantanamo Bay this week as court resumed its search of accountability for those who allegedly planned the worst ever foreign attacks on U.S. soil. Retired FBI Special Agent James Fitzsimmons testified that he partnered with CIA personnel in early interrogations of two of the 9/11 defendants while the men were still held by Pakistani authorities after their April 2003 capture. On Wednesday, he said that he and an unnamed CIA officer interrogated Amr al Baluchi, the nephew of Khalid Sheikh Mohammed, and Wali bin Attash, also known as Khalid, in the days before Pakistani authorities transferred the men to CIA custody, where they endured years of isolation and abuse at CIA overseas black sites. Now, here's the problem is that you had a number of Islamic militants like Ramzi Youssef, the mastermind of the first World Trade Center bombing in '93, who was actually captured in Pakistan. He wasn't tortured. He talked right away to the FBI. Now you also had Abdul Hakim Murad. He spoke, but he was actually beat up by Philippines authorities. But he was involved with the Pachinko plot as well. You had Omar Abdel Rahman, the blind sheikh, the co-emir of Gamma Islamiyah, an Egyptian Islamic group, who basically was arrested and sentenced for his role in the landmarks plot. They didn't have to torture him, right? Khalid Sheikh Mohammed, the alleged mastermind 9/11 attacks, he actually was captured by Pakistani authorities, and he was talking in Pakistan. In 2014, the Senate Select Committee on Torture released its report and said that Khalid Sheikh Mohammed and Ramzi bin Ashib were captured in Pakistan, and they were actually talking with Pakistani authorities. CIA didn't have to torture them. They were willing to talk. I just did a video just a couple of days ago where James Mitchell and Bruce Jessen, the authors, the CIA psychoanalysts who were hired to conduct the enhanced interrogation technique program, torture program, on enemy combatants. And they even said that when Khalid Sheikh Mohammed was talking about 9/11, they tortured him because they didn't want to hear about 9/11. Why? Listen, if it's laid up to rest that the all the evidence or most of it is going to come from your detainees, why would you torture them knowing that it was going to be inadmissible? Now, the reason why the CIA did this to them was because they wanted information right away about future attacks inside the United States. That's why they were torturing them. Defense lawyers sought Fitzsimmons' testimony to support their argument that coordination between the CIA and the FBI requires the judge to suppress the confessions that FBI agents elicited from the men on Guantanamo Bay in early 2007 after the accused had left the black sites. Now, this is the whole argument. After they were renditioned to Guantanamo Bay, Khalid Sheikh Mohammed, Tawfiq bin Attash, they spoke with the FBI. And according to them, they confessed about their roles and planning of the attacks, and that the FBI built its case on this. However, the defense lawyers are saying that they were conditioned to say that in fear of being tortured again. And now it's up to McCall, the judge, to make that decision by mid-April at least. The CIA's torture conditioned the defense to say what the interrogators wanted. Defense lawyers claim the FBI built upon the fruits of the torture they further assert in building its criminal case against the four defendants, who also include the accused 9/11 plot mastermind Khalid Sheikh Mohammed. James Connell, Al Baluchi's lead lawyer, questioned Fitzsimmons throughout the hearings Wednesday and Thursday. He told reporters outside the court that the testimony helped establish the cradle to grave nature of the FBI CIA joint effort, dismantling the myth that the FBI was removed from the rendition program. He also claimed the program was useless and horribly unnecessary, pointing to CIA cables documenting early interrogations in Pakistan that showed the detainees were cooperating to various extents prior to entering the black sites. Several of those documents were displayed in court. One CIA cable noted of Al Baluchi, when asked direct questions, he generally responds with information. So it makes you wonder why they would need to torture these people when they were talking freely anyway, while they were in Pakistan. You know, it's frustrating because you wonder if just like, are they that stupid? Are they that ignorant? Are they that brutal? Could be a combination of all. Maybe I'm giving them too much credit that they wanted to torture these people as revenge, and they didn't give a shit what they had to say about 9/11 because they themselves were breaking the law. Because in the year 2000, it was the CIA running an illegal operation with Saudi intelligence monitoring two Al Qaeda subjects, Khalid al-Mihdhar and Wafa Hasbi, while they were living in San Diego and Los Angeles. They didn't tell the FBI about that or the State Department. Prosecutors have portrayed the coordination between the FBI and CIA as a natural and necessary response to the attacks that many of the government feared would be followed by even worse strikes. That's what they believe. That's not based on anything. And if you read the Senate Select Committee on Torture in 2014, which they did a movie on, The Report, with Adam Driver playing Daniel Jones, who co-authored the report, it basically says that the CIA basically were lying, that they didn't stop any plots, and that there weren't any future plots. Now, if we go by the documentary record, Al Qaeda split in two after the 9/11 attacks. Some of bin Laden's family went with him to Waziristan and then later Pakistan, and bin Laden's wife and son Saad bin Laden went to Iran, where they were placed under house arrest. Later on, Iran basically tried to make a deal with the United States saying, hey, we can hand over Saad bin Laden to you. And the United States said, no, we're not interested. And I think the reason why they did that was so that they could say, hey, Al Qaeda's in Iran. That's who they're supporting. And nothing could be further than the truth. Iran doesn't support Al Qaeda based on ideological differences alone. They contend that incriminating statements given to FBI agents on Guantanamo Bay in early 2007 were made voluntarily, were not products of torture. Prosecutors have said those statements are critical to the case they hope to one day present to a jury of military officers in a trial that could eventually result in the death penalty for the accused. The judge, Air Force Colonel Matthew McCall, is in the midst of a 4-week session intended to stretch into March and resume for 5 weeks in mid-April. He intends to complete testimony from both defense and government witnesses over the contested statements during these sessions. He told the parties that they may rule on whether to suppress the FBI statement prior to his retirement later this year. If McCall declines to rule, defense lawyers have said they have dozens of additional witnesses to support their case for suppression. Now, if that's the whole, if the FBI basically has just the 2007 confessions, they're in trouble. Because if McCall rules against that, they have nothing. Now, the CIA has the videotape of the interview of Khalid Sheikh Mohammed he did with Yossri Fouda at Al Jazeera before they were captured. Yossri Fouda from Al Jazeera co-authored a book with Nick Fielding, who I interviewed on my show, Masterminds, etc., that talked about Khalid Sheikh Mohammed confessing to Yossri Fouda with Ramzi bin al-Shibh at his side, talking about how they orchestrated the planes operation and provided logistical support and financial support to the operatives involved. This is before they were captured. According to Nick Fielding, that the CIA has that tape. The recollections offered by Fitzsimmons this week of decades-old experiences were occasionally hazy and made more difficult to parse in a public forum due to the case's unique national security concerns. Over 3 direct examinations on Wednesday, exchanges between defense attorneys and Fitzsimmons triggered the courtroom security protocol, setting off a flashing red light and interrupting the public feed to the viewing gallery 9 times. As has happened repeatedly in prior sessions, the prosecution asked the court security officer to cut the feed either because of concerns the discussion would stray to classified matters or because the government has asserted a national security privilege over the information. Prosecutors can request the interruption will be directed to do so by a remote entity from the Intelligence Committee via tablet. And this is where the frustration sets in for the Judge McCall, because he's not running the show. It's the federal government and the CIA. And they get to dictate what evidence can be heard through the public feed and what does not, what could be classified and what is not, what could be deemed classified and what is not. While Judge McCall typically exudes a calm and affable presence in court, he has begun to more frequently express frustration over the interruptions because he knows he's not in charge. The first interruption, for example, occurred because of the mention of unique functional identifiers, also known as UFIs, of CIA officers, which are three-digit codes used to protect a person's covert status. The government's managing trial counsel, Clay Trivett, said after a 50-minute delay that any use of the UFIs for CIA personnel involved in the Pakistani interrogations would have to take place in a closed session. Why? The UFI is protecting the name anyway. And look what McCall says. Isn't that why we have UFIs? So that we could use UFIs in open court? Saying it might make sense for him to require lawyers from the intelligence community to come to court. Why not? I don't want to yell at you, but sometimes I feel like I should yell at somebody. McCall is saying, now when the judge is saying this, there's problems. Right? There's problems here. Tensions escalated in the afternoon when the examination by lead lawyer for al-Hawsawi, Walter Ruiz, set off the security light as Ruiz attempted to ask Fitzsimmons about an unclassified document, the nature of which was not revealed to the public. Ruiz told McCall that the government's limitations were preventing him from being effective in presenting his case and denying his client a public trial. We've come to accept that as the normal course of things, and it simply cannot be. And he's right. McCall responded that he shared the defense team's frustrations and said he would consider unspecified remedies to sanction the government. Ruiz continues, saying that he wanted to express clearly for the appellate record that it was becoming impossible to continue to bend to the will of the government. There may very well come a time when we just stop playing this game, Ruiz said. Trivett arose from the prosecution table and said interruptions would continue to happen if the defense teams insisted on going up the line at which unclassified material crosses into the classified. Testimony resumed until minutes later, the red light was again activated. Ruiz argued to McCall that both the document he was referencing and his questions were well within the guidance provided by the government on what information can be used in court. No one says you caught that ball too close to the line, Ruiz said, likening his team's crafting of a witness examination for a public session to a wide receiver making a catch within the bounds of the football field. Last fall, McCall indicated that the restrictions imposed on defense teams will factor into any ruling he makes on the inadmissibility of FBI statements. The original judge to grapple with the case, Ermy Connell James Pohl, suppressed the FBI statements in 2018, citing the prohibitions in place to this day that prevent the defense teams from independently contacting any CIA witnesses who may have knowledge of the interrogation program. His successor, Marine Colonel Keith Perella, reversed Pohl in 2019 and ordered the defense teams to present the case why the statement should be suppressed. Suppression hearings commenced in September of 2019, presided over by the third judge in the case, Air Force Colonel Shane Cohen. His retirement in March of 2020 and delays forced by the COVID-19 pandemic resulted in McCall basically overseeing the crucial battle. And what a battle it is to get this stuff suppressed. Since hearings resumed last fall after a lengthy and unsuccessful attempt at plea deals, old wars have been waged anew. Ruiz reminded McCall that late last year, his team had filed a motion to resurrect Pohl's initial decision to suppress FBI statements based on the investigative restrictions. In the aggregate, this is an unworkable process, Ruiz said. As the session commenced, Ruiz asked McCall to dismiss the case against his client for outrageous government conduct, claiming that the CIA's program met the U.S. Supreme Court standard of behavior that shocks the conscience. And if you read the report's the 2014 Senate Select Report, the amount of torture that people like Hawsawi went through and Khalid Sheikh Mohammed was unprecedented in any level, anywhere in history. And that's saying something. Ruiz described the program as an international criminal enterprise in which the U.S. government spent vast sums of money to illegally traffic detainees between foreign torture pits and brutally extract information for the purposes of both intelligence gathering and building criminal prosecutions. The violence and depravity of the government's conduct was unprecedented in American court cases, he argued, which he's right. You ever heard of anything like this in your life? The al-Hawsawi team was the first to move forward seeking dismissal of charges against their client based on outrageous government conduct. Ruiz told reporters in advance of the hearing that while the motion significantly overlaps with the case to suppress the FBI statements, it also provides McCall another avenue to sanction the prosecution, either by dismissing the case, removing the death penalty as a sentencing option, or suppressing the statements. How about all of the above? In court on Monday, Triviat disagreed. He portrayed the motion as legally unsupported and told McCall that the only remedy open to the defendant was the ongoing effort to suppress the statements. It would have been outrageous if the FBI, CIA, and other government entities did not coordinate in aggressive efforts to stop the next attacks at 9/11, he countered. But there was no follow-up attacks. That's repeated in the Senate 2014 report. There was no future attacks. And according to, if we're going to go by the words of Khalid Sheikh Mohammed and Osama bin Laden, after 9/11, Al-Qaeda split in Afghanistan. Some of bin Laden's family went to Iran, including his son Saad bin Laden, and bin Laden's and his wife. And bin Laden went to Waziristan and later Pakistan, where he was surrounded by U.S. Special Forces and the CIA Special Activities Division in an operation called Operation Jawbreaker, in which he traveled with, I think, 400 Al-Qaeda soldiers at that point, and Dr. Ayman al-Zawahiri. And then the leader of the operation, Gary Bernstein, called for 200 more special operations soldiers to basically block off the back entrance into Pakistan, and he was told no. So bin Laden went to Pakistan and lived for another 10 years. There's a reason for this. According to Gary Bernstein, CIA, Operation Jawbreaker leader, basically said in his book, Operation Jawbreaker, that it was basically for the threat of Al-Qaeda to exist because the U.S. invasion of Iraq was next. And that the soldiers couldn't go to Pakistan because there's a bigger issue, Iraq. And who led that charge? People like Richard Perle, Paul Wolfowitz, Douglas Feith, the dual Israeli citizens in U.S. government. Yeah, that's who. And not only that, with bin Laden alive, the Al-Qaeda threat is alive as well. So it serves as a dual sword. Al-Qaeda exists because they need Al-Qaeda to exist for Iraq. How else can we invade Iraq without the threat of Al-Qaeda? We killed bin Laden, we killed Dr. Ayman al-Zawahiri, and guess what? Al-Qaeda doesn't exist anymore. And now we can't invade other countries like Syria and Libya and use those proxy forces to overthrow those governments. That's what we did with Timber Sycamore in Syria. The CIA led that charge, thanks to Obama. So they needed Al-Qaeda to exist. And bin Laden did. And with bin Laden's family in Iran, you could point to Al-Qaeda in Iran, even though they were under house arrest. And Iran basically wanted to hand over the family members to the U.S. government, as per a Times article in 2007. Ruiz's presentation on Monday to establish outrageous conduct was largely opaque to those who viewed from the public gallery. He presented dozens of documents to McCall pertaining to the conditions of al-Hawsawi's confinement that were neither shown to the public monitors nor described in any meaningful detail. Ruiz claimed the restrictions were intended to hide the government's dirty secrets rather than protect national security. What do you think? Ruiz's presentation on Monday to establish outrageous conduct was, al-Hawsawi endured extreme torture at a black site referenced to in court as Location 2 or Cobalt, which CIA personnel had previously described as a dungeon, where merely being present was an enhanced interrogation technique, Ruiz explained. He said that among other acts of violence, interrogators waterboarded his client and also raped him with a rectal exam of such force that it left him with permanent damage. It's amazing the CIA did here, and they fucked over this case. Prior to, James Mitchell and Bruce Jessen, they belong under the jail in The Hague. Prior testimony to decodifications have established that al-Hawsawi later spent time on Guantanamo Bay when the CIA used a portion of the detention facility at a secret black site between 2003 and 2004. Ruiz's examination of Fitzsimmons on Wednesday failed to establish where or when he interviewed al-Hawsawi in a stilted exchange interrupted once again by the security light. Fitzsimmons referred to an unspecified project, uttered the word here when seeking clarification to one of Ruiz's questions, though it was unclear if he was referring to Guantanamo Bay. Fitzsimmons testified that he knew at the time he interviewed Hausawi that the detainee had been through the agency's enhanced techniques. The agent did not know which particular methods had been deployed. He testified that Hausawi complained of extreme physical comfort and that staff at the location provided him with medical assistance for severe hemorrhoids. The government has previously disclosed that some FBI agents were detailed to CIA black sites and that at least 9 FBI agents became CIA agents. They're actually not called agents, they're called officers, for a period of time during the black site program. In his continued testimony on Thursday, Fitzsimmons testified he was unaware of that arrangement. Fitzsimmons began his FBI career in 1978, retired from the FBI in 2005. He wore a headset throughout his testimony in Guantanamo Bay courtroom to assist his hearing and regularly asked attorneys to repeat their questions. After court, defense attorneys said that they could not make any comment that might reveal the timing or location of the al-Hausawi interviews. The lawyers continued their examinations of Fitzsimmons over several additional hours in a closed session on Friday. Throughout his public testimony on his time in Pakistan in 2003, Fitzsimmons said that he and his CIA colleague used traditional interviewing techniques during their sessions with al-Baluchin and bin Attash. On Thursday, during questioning by Tassim Motala, one of bin Attash's civilian lawyers, Fitzsimmons said that the suspect showed no signs of having been mistreated despite Pakistan's reputation for abusing prisoners. He acknowledged that he told bin Attash that his cooperation would help him avoid the fate of arriving at an American prison where he'd be surrounded by violent criminals. Now bin Attash is probably thinking, I was better off in an American prison, right? Because look what happened to me. And what happened to him was much worse than any American prison, right? Doesn't that sound like a threat? Mottola, who conducted the examination from the court's remote hearing room in Virginia, asked. No, Fitzsimmons responded as a statement of reality. Dr. James Mitchell, one of the two, other is Bruce Jessen, CIA contract psychologist who played a lead role in developing the CIA's interrogation program, began his testimony on Monday of the second week of the hearing. He first testified in January 2020. I did an article about his hearing not a couple of days ago. At the start of court on Wednesday, Trivet revealed that Fitzsimmons was, in fact, one of 2 FBI agents detailed to the Guantanamo Bay black site to debrief al-Hausawi and other CIA detainees held there. He told McCall that this fact had earlier been declassified by the government, but did not make it into the classification guidance for examining the witness in the open session. It is unacceptable, Trivial said of the error, adding that he took full responsibility. Multiple lawyers from the defense teams rose to tell McCall that the government's error had prevented the public from learning important facts about the FBI's role in the black site program, for which the FBI continually over the years denied that they were a part of, meanwhile they were a part of. The harm has been done, Ruiz said. We cannot continue to do business this way. The harm is done is right because these people gave testimony, gave information under the duress of torture, which can't be used in a court. And now it's up to the military judge McCall to whether the FBI's memorandums and interviews of Khalid Sheikh Mohammed, of Tawfiq bin Attash, Mustafa Hausawi, and Amr al-Baluchi in 2007 can be used for the prosecution to prosecute these men for the 9/11 attacks. If McCall makes that decision that they can't use that testimony, then the government basically really has nothing. What about the videotape of Khalid Sheikh Mohammed and Ramzi bin al-Shibh in Pakistan? Could that be used? That was before they were tortured. Well, according to Nick Fielding, the CIA has it. What happened to it? I don't know what to tell you, but it basically comes down to this. If McCall makes that decision by mid-April, the government is going to try and push another deal with the death penalty off the table, which they already did, and they couldn't come to an agreement. Now, can you imagine if a trial ever happens and they can't use this evidence? Imagine the horror of these men walking out on these charges and going back to their home countries, or being found not guilty of these charges and being held for indefinite detention at Guantanamo. That would mean that nobody is responsible for the 9/11 attacks. All right, guys, look, like I said, this was a fantastic article by John Ruiz. Lord Dragon's been covering the pre-trial hearings. One of the best, just like Florida Bulldog. Excellent coverage. Thank you for tuning in. See you in the next video, everybody.